seem to be a temporary. How could it be?
Sibal, sorry interrupting you at this stage. It does maybe just putting a question.
Sure,
I'm
sure.
not. If one looks at Article 370, enacts the Constitution.
Government was always in place from day
No,
one.
no, maybe so.
Government is always in
Because
place
that
from day one.
that appears to be the broad outline of this.
If Article 3 goes, then that means Article 370 can never be abrogated.
Yes, that's the whole point, Mullah. That is our case.
Then how it is temporary?
It is temporary because in the abrogation of 370. Otherwise, if your lordship says it had no role to play, there was no need for 370 sub Article 3. And look at the concurrence power. Even those powers were of no relevance thereafter because the constitution of Jammu and Kashmir was in place. There was no need for concurrence anymore. Because now you have a constitution of the Jammu and Kashmir. So that also became OCOs. You have to see, Malad, the historical perspective in the context of which Jammu and Kashmir ultimately signed the instrument of accession. Nobody disputes whether they are integrated into India, but subjected to a constitutional provision.
Therefore, the submission is that once the period stipulated in the proviso to clause 3 had come to an end,
Yes.
the power under clause 3 itself came to an end.
Because it's no longer alive. The Constituent Assembly, like in India, Malaj, can, for example, today, Malaj, there can't be a provision in the Constitution of India with reference to a Constituent Assembly, because the Constituent Assembly has worked itself out. It has formed the Constitution. Now, if it is decided that they would abrogate 370, the Constituent Assembly would have said, we abrogate 370. Which is why it was a temporary provision. Not because of the fact that under as a Union of India, it was deemed to be a temporary. How could it be?
Sibal, sorry interrupting you at this stage. It does maybe just putting a question.
Sure,
I'm not. If one looks at Article 370, clause 1B.
1B, yes.
The power of the Parliament to make laws for the state shall be limited to, it says, matter in the union list and the concurrent list in consultation with the government of the states are declared by the President to correspond to matters specified in the instrument of accession governing the accession of the state to the Dominion of India.
Right.
To such other matters in the list as with the concurrence of the state government of the state, the President may in the order may specify.
Yes.
Then explanation deals with what is meant by the concurrence of the state.
Right.
Then it says that provided that no such order, the first proviso, provided that no such order which relates to the matter specified in the instrument of accession of the state, referred to in paragraph 1 of subclause B, shall be issued except in consultation with the government of the state.
Correct.
Provided further that no such order which relates to matters other than those specified in the last preceding proviso shall be issued except with the concurrence of the government.
That's right.
So the second proviso talks about concurrence of the government.
Yes.
Now, if one looks at clause 2,
Yes.
it deals with a situation where the assembly or the government of the state is not there. It deals with the period when the constitutional assembly of the state was in existence, but the government or the elected assembly was not in existence. And therefore, the proviso to clause 3 will only be applicable as long as the government of the state or the assembly is not elected. Because election of the assembly will take place after the constitutional assembly of the constitutional assembly of the state of Jammu and Kashmir enacts the constitution.
Government was always in place from day
No,
one.
no, maybe so.
Government is always
Because
in place from day one.
that appears to be the broad outline of this, outline of Article 370. What clause 2, when it refers to the Constitutional Assembly of the state, it is for the purpose of constitution of the, for framing the constitution of the state, which shall be placed before the assembly for such decision as may be taken thereon.
Correct?
So the Constitutional Assembly of the state makes the constitution, frames the constitution, it goes before the constitution.
No, it can state in the constitution that that the 370 is abrogated. What problems are there? It has the power. That's why there is a constituent assembly. And it says, Malaj, notwithstanding anything in the foregoing provisions, kindly note that. Notwithstanding, Malaj, 37(1)(b)(1) and 37(2). Notwithstanding any of that. So, Malaj, you start the article by saying notwithstanding anything in this constitution, and 3 starts with notwithstanding anything in the foregoing provisions. That is notwithstanding the opening part of the article also. There was a government, yes. Yes.
Extent of Constituent Assembly of the state.
Yes.
If sub-article 3,
Yes.
according to you,
Yes.
has become non-existent, ceased to operative,
Yes.
then how the very temporary nature of Article 370 will survive?
That's why, because it's temporary, because the Constituent Assembly had not been framed, but at that point in time had not been constituted in 1950 when this provision was added in the Constitution.
No, if sub-article 3 goes, then that means Article 370 can never be abrogated.
Yes, that's the whole point, Manoj. That is our case.
Then how it is temporary?
It is temporary because when this article was framed, Manoj, there was no Constituent Assembly. It was the Constituent Assembly which could have taken the decision that we will abrogate 370 and merge completely with the Union of India like any other state.
Mr. Sibal, your contention, if I've understood you correctly, is that the temporary nature of 370 is correlatable to the
Life
Constituent
of the
Assembly
Constituent Assembly.
life.
That's my
And
argument.
in a way, subclause 3 becomes otious once the Constituent Assembly ceases to exist.
Correct.
This is your contention.
My contention.
From 51 to 57, it is temporary.
Your lordships of the Constituent Assembly, they say the same thing. Mr. Iyengar, they say the same thing, what I'm saying, Manoj.
I'm just trying to phrase it as I understand
I-
it. because
I-
I'm clear
The
that
lordships have understood it, and I also understand your lordships, what your lordships are thinking, Manoj. So I have to respond to that.
According to it is temporary between 51 to 57
That's correct.
and thereafter permanent.
The reason is simple, Manoj, all constituent assemblies are temporary. There is no permanence in a constituent assembly. So when you,
Role is limited to framing the constitution.
yes. Therefore, Manoj, if it is temporary by its nature, which is why I started by saying this is a political exercise. That's why I, Manoj, started with that summation before your lordships. The formation of a constituent assembly is a political exercise to ensure that people within the territory of a particular region, their aspirations are taken into account to formulate a law and a constitution to ensure that those aspirations are met in future times to come. It's not a law-making exercise. Then they framed the constitution to take into account those aspirations. That's how our republic came into force. Because there was the 1935 Act, there was diversity. Well, let's kindly look at it historically. Let's not forget the law for the moment. Look at it historically. If you look at Europe and the making of the nation states in Europe, how did that happen? It happened because there were large empires, the Austro-Hungarian Empire, Prussian Empire. And whereas those large empires had communities and within those empires, there were peoples of different languages, of different cultures, of different ethnic lot. So it is the breakup of the empire that led to the rise of the nation state, the Treaty of Utrecht, the 1848 revolutions.